everyone, and welcome to today's program, The Nuts and Bolts of Federal and State Vaping Laws. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Azim Chowdhury. Azim is a partner at Keller and Heckman LLP in Washington, D.C., and is a nationally recognized authority on tobacco nicotine product regulation, advising domestic and international clients on complex compliance issues before the U.S. Food and Drug Administration and global regulators. His practice focuses on the evolving legal landscape governing tobacco, e-vapor, and next-generation nicotine products. He counsels manufacturers, distributors, and trade associations on regulatory strategy, public policy, and product approvals. In addition to his advisory work, he's a prominent thought leader, author, and speaker on tobacco regulation, contributing to key industry publications and initiatives that influence the direction of regulatory policy and compliance practices in this highly scrutinized sector. We're so excited to have him here with us today, so I'm going to turn it over to him.
Great. Thank you for having us, for having me. And for those of you who are attending live, thank you for joining and missing the first few hours of March Madness. But we only have an hour today, so I am going to go ahead and jump right into this. See if I can share my screen here. All right, where did it go? Okay, I think it's working. If it's not, please let me know. But
We don't see your screen right
you
now,
don't see my
Azim.
screen yet. Okay, hold on a second here. Screen two, how about that? Does that work?
Loading. Yes, perfect.
Okay, fantastic. All right, well, yeah, we're here today to talk about the exciting world of vaping, e-cigarettes, and a little bit about other nicotine products as well, which is, now under heavy FDA regulatory scrutiny. But first, a little bit of background on Keller and Heckman. We are a law firm based in Washington, D.C., but with a global presence with offices in San Francisco, Boulder, Brussels, and Shanghai. Established back in 1962, we are about 80 attorneys globally with about 20 scientific staff, which kind of makes us a bit unique because we do focus heavily on regulatory and technical submissions. And so if you have any questions about any type of FDA, environmental, or regulatory issue, please feel free to reach out. Very quickly, just quick plug. We host our annual e-vapor, nicotine, and tobacco law symposium every year in Las Vegas. This upcoming event is going to be the 10th annual one, so a big deal for us. Please feel free to join us. It's a good event. It covers the things we're talking about today over and much more over 2 days. And it's well attended by folks in the industry and their attorneys. So if this is of interest to you, please feel free to reach out and register. All right, so the focus of today's discussion is going to be vaping. And what that means is, using e-cigarettes or electronic cigarettes. So before I get into the legal issues, I thought for those of you who may not be as familiar with these products, a brief background might be helpful. So e-cigarettes are battery-powered devices that do not contain any tobacco material, tobacco leaf, but rather contain what's called an e-liquid. That is a solution of components like different bases, such as propylene glycol, glycerin, flavor compounds, and of course, nicotine. The way this e-cigarette works is the e-liquid here is which is contained in a storage unit, is heated by what's called an atomizer that turns the liquid into a vapor that can be inhaled by the consumer. There are different types of e-cigarettes, primarily in two different categories, what are called closed systems, which initially were called cigalikes because they were designed to look like a traditional cigarette. But now you see both open systems and closed systems. The main difference between an open system and a closed system is that a closed system is a completely sealed unit with the e-liquid pre-filled by the manufacturer, whereas an open system comes in two different pieces. You have the hardware component, which is a device with a tank that can be refilled with e-liquid, the flavored e-liquids that consumers can purchase on their own, and they can use whatever e-liquid of their choice with their reusable open system device. Within the closed system category, you have two different main subcategories. You have pod systems, which if you're familiar with a popular device called the Joule, that's a pod system example where there is a component that is pre-filled, again, because it's a closed system, but once the user consumes the e-liquid in the pod or the cartridge, they dispose of that cartridge and then can use another cartridge, which could be a different flavor, for example. Disposable e-cigarette, or a vapor product, is just like a pod system, except there's no pod. The whole thing is pre-filled and is disposed of once it's has been consumed. All right, so now we're going to jump into the legal framework. So this all started, believe it or not, way back in 2009, which I say way back, but really wasn't that long ago when you think about things that FDA regulates. But it was back in 2009 that FDA was given the authority to regulate tobacco products for the first time when Congress passed the Tobacco Control Act. What that law did was give FDA authority over all things that contain um, substances derived from tobacco, made or derived from tobacco. Prior to this law, FDA actually did not have any authority over tobacco products. That's not to say there was no laws around the use of these products. There were, but mainly in the form of advertising restrictions, warning labels, etc., that were by and large regulated by the Federal Trade Commission. Um, and at the state level, in terms of where products could be used, where they could be smoked, for example. But there was no actual federal oversight over the manufacturing of these products, the ingredients, how they're made, what goes into them, how they're marketed at the federal level. That changed in 2009. But and the key thing is, even though FDA was given authority over, again, broadly, anything made or derived from tobacco, the statute, the Tobacco Control Act, only gave FDA the authority initially over certain categories of tobacco products. So those are the traditional products that I refer to, which are cigarettes, smokeless tobacco like chewing tobacco, and roll your own tobacco. Those are the only initial kind of categories of products that were subject to FDA's immediate authority. What FDA did, what the Congress did say was that to the extent there are other products that meet the definition of a tobacco product, it would be up to FDA to promulgate a regulation to capture those products. So FDA would have to go through a rulemaking process to decide what other categories of products, whether those are e-cigarettes or Ns as we call them, cigars, heated tobacco products. Today we're seeing a lot of oral nicotine pouches, which I'll talk about. All of those would be considered products that would be subject to FDA's authority following, their deeming of them to be tobacco products. And so there was this kind of regulatory gap between the initially regulated products in 2009 and until FDA passed a rule extending that authority to other products, which they finally did in 2016 with what's called the deeming rule. And then in 2022, there was another change to the law. This one was a change to the statute itself, where Congress redefined tobacco product in the TCA to include not just products made or derived from tobacco, but products that contain nicotine from any source. And the reason for that, as we'll see, is because there was this loophole where synthetic nicotine or nicotine that is not derived from tobacco was not under FDA's authority. And once companies started realizing this, we saw a shift to synthetic nicotine in 2020, 2021. by companies seeking to avoid the authorities, the regulation. But that was nipped in the bud in 2022 with the amendment to the law. A quick note here, you'll see I mentioned pre-existing or grandfathered products. As we'll see, the main requirement for tobacco products under the TCA is the requirement for pre-market authorization. A pre-existing product is a product that was already on the market prior to or as of February 15th, 2007, which is known as a grandfather date. So we'll talk a little bit about that in a moment. So in terms of the requirements of the TCA, the main ones are listed here include registration of tobacco manufacturing establishments. So any location where tobacco products are being made or packaged would have to register that facility with FDA if they are located in the domestic US. That requirement does not apply to foreign manufacturing establishments. That's been a big issue for many years. It's impacted the enforcement of this category. And we're seeing FDA just recently announce efforts to extend the registration requirements to foreign establishments. Companies are required to report their ingredients to FDA in terms of what is being used in those products, including tobacco and when it comes to e-cigarettes, the e-liquid components. They're required to update FDA with respect to any health documents. So those are studies that are done on the safety of the product, et cetera. Those have to be separately submitted to FDA, separate from the pre-market authorization requirement for certain categories of products. Then you have a variety of labeling and nicotine addiction warning requirements that need to be both on the product and at the point of sale. And we separately have a requirement as of 2021, the federal age to purchase tobacco was raised to 21 years old. But all those are relatively easy in terms of regulatory compliance. What's difficult about the TCA and the FDA regulation is the requirement for pre-market authorization. So I'm going to talk briefly about the different pre-market pathways. There's three of them. There's substantial equivalence, which applies primarily to those original statutory products, cigarettes, smokeless tobacco, and roll your own tobacco. The reason is because substantial equivalence requires that there be a grandfathered predicate product that the new product can compare itself to, right? So again, all new tobacco products that are not grandfathered need to go through pre-market authorization. It means they have to be approved or authorized for sale by FDA affirmatively. Only grandfathered products that were on the market in commercial distribution prior to the grandfather date are exempt. So cigarettes, which are the most prevalent still and most harmful tobacco product, because those products have been around for a long time, and the companies that produce those products have evidence that they were selling those for many years, they are largely grandfathered and exempt from pre-market review. To the extent a cigarette company, for example, wants to make a change to their product, either to the type of tobacco or the filter or the paper, they would have to go through pre-market review, which would trigger, for example, which would trigger here substantial equivalence. And the standard for that is to demonstrate that the change that they're making to that cigarette, to the paper, to the filter, what have you, does not raise new or different questions of public health. What that basically means is FDA wants to make sure if you're making a change to a product that's grandfathered, that change is not going to make it more harmful or more addictive. Then you have what's called substantial equivalence exemption request, which again, it applies to the same category of pre-existing or grandfathered products looking to make changes. And basically, it's for very minor changes to additives in the pre-existing or grandfathered product that are so minor that they don't qualify for the full-blown substantial equivalence process. So it's fairly limited use. But again, that also requires a predicate pre-existing products. The bulk of what we're going to talk about today is the PMTA, pre-market tobacco application, because that is what applies to vapor products or e-cigarettes. The reason the PMTA is the only pathway that applies to vaping products is because there are no grandfathered versions of vaping products. The first e-cigarettes came to market in the US late in 2007, is what we have discovered, or early 2008 from China. And so the earliest known e-cigarette that was sold in the US um, was just barely missed a sort of grandfather deadline in February 2007. And so what that means is the entire category of e-cigarettes is considered a new product. And so every single product, in order to be sold legally, needs to go through the PMTA process. Now, what's interesting about this process is that the legal standard for authorization is demonstrating that the product is appropriate for the protection of the public health. Well, what does that mean? Well, it's a very high standard, right? If you're familiar with FDA, you might have heard of the safe and effective standard that applies to drugs. This is similar because it does require assessing the risks of the product, the safety of the product to the individual consumer. But in my view, it's an even higher standard because it requires assessing the population level effect, right? FDA says that for a product to be APPH, the company must demonstrate the overall benefit to the population as a whole of that product, including both users and non-users, taking into account the potential for increased or decreased cessation. What does that mean? Cessation means, does the introduction of the new product help people essentially quit smoking, right? As well as the potential for increased or decreased initiation. What does that mean? It means, well, does the availability of this new product, could it impact people initiating into tobacco or nicotine use, in particular youth? We don't want kids to start using nicotine or tobacco. And so how does the availability of this product impact the overall youth rates of tobacco use? And so these are all the types of things that must be considered in a variety of different types of studies, including clinical trials, behavioral studies, population modeling studies. It's a wide range, multidisciplinary effort that can cost millions of dollars to prepare. In terms of resources, there's no one-stop shop guide to what's required. It's been a bit of a jigsaw puzzle for many years, trying to figure out what is required. What studies does a company have to do for different types of vaping products, for different types of flavors? And FDA has, over the years, since the deeming rule in 2016, we have seen a number of guidance documents that have been published on the requirements for PMTAs and e-cigarettes. We have seen a final rule that went through a separate rulemaking process that became final at the end of 2021. We have a variety of what are called regulatory science policy memoranda that FDA publishes from time to time, providing details on their internal review in terms of different disciplines like chemistry, toxicology, et cetera. Then FDA from time to time will have public meetings where they have, they open the door to the industry, to stakeholders, to ask questions, for presentations. And recently they had a roundtable discussion on for small companies in this space seeking to do PMTAs. So these are the types of resources out there that you or your clients might be looking to find if you're looking to prepare a PMTA. In terms of the PMTA process, there are several steps, right? First is if you're able to, you recommend meeting with FDA and proposing to them your strategy for your studies, your testing protocols, et cetera, to get an idea of whether or not you're going down the right path for a PMTA. Once a PMTA is submitted, after that potential pre-meeting, it goes through 3 phases: acceptance, filing, and then scientific review. This acceptance phase is more of an administrative phase, meaning companies that, the PMTAs are reviewed to ensure they have the right forms, that all the products are covered, that the product that's covered is in fact a tobacco product, because sometimes people submit applications for things that are that don't actually qualify for the PMTA process, that you've included all the right basic information in terms of labeling, ingredients, environmental assessments, etc. Companies will then receive an acceptance letter, and the PMT will move on to the filing stage. Filing is a bit more of a um, scientific review, like a mini scientific review, where they look to see, did the company actually include data? Did they include information on test results for harmful chemicals, stability of the product over time? Did they do a clinical trial? And if it looks like, at a preliminary level, they've included that information, then it will go on into scientific review. There are rules that you should look closely at if you're submitting a PMTA to understand specifically what the requirements are and what to avoid to prevent a refuse to accept, for example. So here are some of those CFR citations that identify, again, the right forms, making sure you have the right environmental assessments for the product. To the extent there is a foreign language documentation in the PMTA that must be accompanied by a certified translation. Um, so yeah, those are the types of things that FDA is looking for, and they will. I mean, FDA in this category, they will refuse an application, even if it is comprehensive, even if it costs millions of dollars, if you did not sign the right document, or if you did not include the right form. So it's very critical that you know exactly what to look for and how to avoid those mistakes. Again, when it comes to the filing process, that secondary review, I would look closely at the CFR for the PMTA final rule, because that includes kind of the more specific information that we have now in terms of full information, that they're looking for on the health risks, the manufacturing, labeling. What we see now is that they're looking specifically for evidence that the company did, the key studies required for scientific review. And if that evidence is not there, that those studies were conducted, FDA will refuse to file the application because it doesn't make sense for them to spend the resources to review an application that doesn't have all the information. And then finally, when it comes into the final phase scientific review, this is where you get into the real meat of the PMTA, right? For companies that are doing this the right way, this is where all the evidence and all the data is reviewed, including engineering data, toxicology, behavioral, clinical pharmacology, microbiology, again, population health impact assessments, perception and use of the product. Um, Again, many different types of studies. It would be, it would take a full day seminar like the one that we host in May to go over all of them to understand what is required for a PMTA. So you might wonder, well, if the PMTA process is so difficult and so hard and so time consuming, how is it that um, there are so many products on the market, right? Because if you go into a gas station or a vape shop, you'll see many thousands or hundreds of products available in all sorts of flavors. And many of those are not authorized for sale, right? Because we'll talk about how few of those have been authorized. But the reason in part is because over the years there have been what are known as deferred enforcement compliance policies. The way this all kind of worked out over time created a lot of confusion in the marketplace and in enforcement discretion from FDA, because as I mentioned early on, there was this the law became effective in 2009, and e-cigarettes, although they were on the market and started coming to market around that time period, were not subject to regulation until well later, until 7 years later, until 2016, when FDA passed the deeming rule. So there was this period of time when these products were on the market without any real regulatory oversight. By the time FDA passed that deeming rule in 2016, they knew there was already a multi-billion-dollar industry, um, many hundreds of companies, small businesses, vape shops, people were selling these products. Um, and rather than say automatically on day one of the deeming rule effective date that everyone was illegal, they said, we're going to create a deferred enforcement policy whereby if you were already on the market by the time this rule became effective on August 2016, we're going to allow you to stay on the market for some period of time while we figure out what we need for a PMTA. Because again, it wasn't until 2021 that we got the PMTA rule from FDA, final rule from FDA on what's required for a PMTA. And so companies were complaining, and there was litigation about, well, how can FDA require us to do PMTAs and not tell us what's needed to be in a PMTA or what's needed to meet the statutory standard? Because this is all brand new for FDA. And so there was this periods of time that lasted for several years where FDA said companies could stay on the market pending, pending their, pending their PMTAs if they submitted one while they reviewed those applications because of how long it was taking them to figure out what they wanted. So there was an initial PMTA deadline in September 2020 for tobacco-derived nicotine. Then, as I mentioned, in May 2022, there was another deadline for synthetic nicotine once that came under FDA's authority. Okay, but as of today, right now, if you call it FDA and ask them, is there a deferred enforcement policy? They would say no. Those periods of time have come to an end. They were limited in time. There was some litigation I don't have time to get into on this webinar that forced the initial deadline and then the end of that compliance policy or the deferred enforcement policy in 2021. But so the result of all that, to boil it down, is that today there is no formal enforcement discretion. FDA's position is that to sell a vapor product, it must be authorized through the PMTA process. We're not formally extending enforcement discretion. However, as a practical matter, we know that that's not true. That there is enforcement discretion because there are products on the market that are on the market without authorization, and FDA is not enforcing. It may be because they have pending applications. It may be because of other reasons. They have to prioritize, right? They don't have unlimited resources. And so FDA focuses their priorities on sort of the most, violative products typically. All right, so back to the PMTA. There have been these deadlines over the years, and the result of the PMTA process has been that overwhelmingly, the vast majority, over 99% of PMTAs for vapor products over the years have either been refused or denied. Again, part of that was because of the lack of guidance from FDA on what was required, how much it costs to submit a PMTA, and really just kind of a mess of an enforcement situation. What we ended up seeing happen in late 2021 was FDA started to focus on flavors. And because their concern was youth, young people were starting to use vapor products. In 2019, you might recall there was a huge public health concern about youth vaping and Juul and all sorts of concerns about, these products being on the market and being subject to almost no authority. And so what FDA did as they started reviewing the PMTAs that started coming in 2020 was they created what's called a comparative efficacy standard. Okay, what does that mean? FDA's position was that in order to meet the statutory APPH standard appropriate for the protection of public health, PMTAs for vapor products needed to include robust data in the form of a longitudinal study or a randomized clinical trial demonstrating that the flavored product, the non-tobacco flavored product, was more effective at promoting adults to switch or quit smoking or reduce cigarette consumption above and beyond that of a tobacco flavored product. So what does that mean? That was pretty confusing. What it means is that FDA's presumption is that a flavored product is attractive to youth and therefore raises public health concerns because we don't want kids starting to use nicotine products. So if a company wants to sell a non-tobacco flavored product, they have to do a specific type of study to show why that flavored product is more effective at getting smokers, cigarette smokers, to switch or reduce their cigarette consumption over and above that of a tobacco flavored. So if you're a tobacco flavored vape, then you don't have to do this study. because the data shows that kids don't like those vapes. But if you're anything else, a mango flavor, a fruit flavor, a dessert flavor, then you have to demonstrate this additional benefit over and above a tobacco flavor. In order to overcome that assumption, that presumption that kids will like and likely use potentially the flavored product. Okay, so that was a lot. And that all kind of came about suddenly from FDA in 2021 as they were reviewing these PMTs that had been submitted in September 2020, that first deadline. And FDA, what has come about since then, basically came up with this standard and what they call the fatal flaw. So again, if your product does not contain this particular type of study, it was going to be automatically denied. Um, and so going back to that PMTA review, this is kind of how it played out in reality. Companies had submitted applications, they had met the filing requirement to then have the application proceed to scientific review. But FDA came up with a new kind of step right before the actual scientific review, whereby they looked for this particular type of comparative efficacy study. And they said this was a fatal flaw. If your PMTA doesn't contain this robust data, right, that demonstrates switching or for your flavored product, if it doesn't contain that study, we're not going to look at anything else in the application. We're not going to look at your marketing plan. We're not going to look at what other data you might have to support your application. We're going to deny the application out the gate because, number one, they've received millions of applications, right? They received, um, um, I think, somewhere between 7 to 8 million PMTAs before that first uh, uh, deferred enforcement policy deadline in September 2020. They were completely inundated and had no real way of processing those applications efficiently. And so again, they came up with this fatal flaw review that um, basically required this study. And if it wasn't there, they denied the application. And so we know that because they actually had, checklists. So companies who had their applications denied, who eventually got copies of their FDA decision memos, saw that there was this check boxes where they looked specifically for the presence or evidence of a randomized controlled trial or a longitudinal study assessing this comparative benefit to flavored products to a tobacco flavored product. And if that application did not contain that data, again, it was automatically denied. This caught most of the industry completely by surprise, right? Companies argued, as we'll see in the litigation, that FDA did not give sufficient fair notice that this particular type of study was going to be kind of the be all end all of a PMTA. And so as soon as companies started getting these denials, and they were mass denied. So beginning of September 2021, you'll see FDA press releases where they denied, hundreds of thousands of applications kind of all on the same day. It was mass denials and, put the whole industry in jeopardy. And so companies started challenging FDA. In Section 912 of the Tobacco Control Act, there is a provision that allows companies to, within 30 days of getting an MDO, a marketing denial order, they can petition for judicial review in their home circuit. And so at least 50, if not more, appeals were filed within the next few months in different circuits around the country, as well as a number of probably hundreds of administrative review requests and petitions to FDA, arguing that FDA had not, provided fair notice, that FDA's denials were arbitrary and capricious under the Administrative Procedure Act. So of those many, many cases, there were a number of several key cases I want to highlight. The first was Bitty Vapor in the 11th Circuit. That was a case where the company had a disposable vapor product that came in multiple flavors. They argued they had completed a multi-million-dollar application that included a variety of different types of studies, but they didn't have that specific comparative efficacy study and received the boilerplate MDO from FDA. They challenged that decision in within 30 days in the 11th Circuit, and ultimately they were successful in that case because FDA admitted that they had not reviewed any other part of the application. And the panel held that that was arbitrary, that the FDA had in previous guidance indicated that they were going to review marketing plans and other data and weigh all the evidence um, that this study was required. And in the case of Bitty Vapor, what was unique about this case versus the other ones, most of which went towards, for FDA, was that they had a very unique marketing strategy. They had a very robust youth access prevention plan. They had no evidence that kids or youth were using their products. They had significant evidence that adult smokers, which again, the target population of these products are adult smokers because we want them to use these products and quit smoking because these are much less harmful. Um, but they were able to show the court, Biddy, that their products were much better, they're much safer than cigarettes, were being used by adults, and that FDA had not considered their robust and unique marketing strategy. And the court held that was arbitrary and vacated the MDO. In Fontum, U.S., in another case in the D.C. Circuit, similar situation, company challenged an MDO. This one was for tobacco flavors. And an FDA said, when it comes to these tobacco flavors, the record evidence in the case demonstrated that FDA had not done a robust review of the application. They had not done a holistic review of the evidence and data presented in the application. And so while FDA denied their flavors as well, when it came to their tobacco flavors, FDA said you need to do this more robust study, or sorry, more holistic review, which they hadn't done. So that was another example of a case being an MDO being vacated by the courts. The other case, I'll just quickly for time, go straight to wages and white line. So this is the main case that, as you can see, went up to the Supreme Court last year. What happened in wages was this was an open system company. So open systems here's an example of one of their products, a Vaptasia, Killer custard e-liquid. Here on my slide, this is a bottled e-liquid that is not sold with any kind of device or hardware. It is intended for use in an open system device. So if a consumer has their own open system e-cigarette, they can use this liquid. You can fill the tank on their own and vape their own products. This is an example of an open system. What's interesting about open systems is that historically, they have not been a major concern for youth use. Where we saw kids and young people start to vape, it was primarily in pod systems and disposables, which were, again, much easier to use, much smaller devices. You could hide them, if you're going to school, hide them from your parents. Open systems tend to be much bigger, clunkier, and again, is more of an enthusiast product. If you're a vaping enthusiast, like a cigar enthusiast, you would use an open system. But if you wanted a quick hit, you'd go to your gas station and buy a disposable. And so anyway, just want to bring that point up because, this was an example of a case where there wasn't any evidence that kids were using the product. And so that company had their PMTA denied because, again, they did not have a comparative efficacy study in their application comparing their flavor to a tobacco flavor. And among the arguments raised was that, again, there was a lack of fair notice that this particular type of study was going to be a requirement when FDA had previously said there was no required studies. FDA was going to instead review all the data and evidence and weigh that evidence before making a decision. They argued that FDA changed their position, that FDA again acknowledged that marketing plans were going to be a key factor in the PMTA review, and then ended up not mattering at all. FDA failed to consider the reliance interests of the companies who had spent millions and millions of dollars, working with FDA or basing their PMTs off of FDA guidance to basically, end up in failure. Again, marketing plans were not considered, and then FDA, came up with post hoc justifications for denying products after the fact, right? That in the litigation itself, coming up with new reasons for companies, new reasons that companies got their MDOs. And then there's an argument that FDA effectively enacted a de facto flavor ban by way of this requirement, because the practical effect of this requirement was that no flavors got authorized. And even today, only a couple have been authorized, the menthol flavor. And so was that a de facto ban, which really is a product standard that has to go through notice and comment rulemaking, right? Because FDA can't just ban products without going through the rulemaking process and going through comments, etc. So those arguments were made. When it came down to it, though, the only issue before the Supreme Court, because there wasn't, again, I can't get into the details here because of time. There was an en banc case in the Fifth Circuit. The Fifth Circuit held in favor of the company wages, and on this particular issue, which was then appealed to the Supreme Court. And the Supreme Court held 9-0 that when it comes to the issue of fair notice, that there was no surprise switcheroo, that there was no change in FDA's position based on the historical guidance. So the court said, if you look at all the many, many public documents and guidance over the years and follow the chain of events, companies should have known that FDA was going to focus on flavors the way it did, and that therefore the denials, the MDOs, were reasonably consistent with the agency's prior guidance and in terms of the type of scientific evidence required and this particular type of study. Okay, and so the court said you should have known that sweet, fruit flavored products were going to be subject to a higher authority, specific studies, and that was on the industry for not figuring that out. And so that case was in FDA's favor. A number of these issues, though, are still outstanding, including the flavor ban rulemaking argument. Those issues were essentially remanded back to the Fifth Circuit. So there are now several cases pending before the Fifth Circuit challenge, on those issues. And so the case is not over yet. We're still going to see what happens with those cases over the next several months. And this could very well end up back before the Supreme Court at some point in the near future. Okay, so what products have actually been authorized? Well, this is actually breaking news because it just was announced maybe about a week ago. There are 41 authorized ENDS products now, and really not really 41. It's really like 7 products, and then they have each product has different components or flavored pieces to it. But a total of 41 different units have been approved by FDA or authorized by FDA, including again recently a company called Glass, GLAS, which is an independent company that is not associated with big tobacco and is not Juul, which is also not big tobacco, but is not necessarily considered a small company. Glass received their authorization just last week for a tobacco flavored device that, as we'll see, has what's called built-in device access restriction. So there's this new push from FDA to get companies to use built-in age gating technology like Bluetooth or NFC chips that will prevent unauthorized use of a particular product. Very technical, and again, we don't have time to get into it today, but you're going to start to see more of those types of devices out there that use the same kind of technology you might see in your phone to lock a device so that only the authorized user would be able to vape it. Notably, we do have some recent authorizations of menthol flavors, including Enjoy Daily and Enjoy Ace Pod, as well as the Juul menthol pod, which was recently authorized. So FDA has finally opened the door to menthol products, but not much more beyond that. Okay, so what are the key features of products that are approvable or authorizable by FDA? Companies have to show that they are less toxic than cigarettes, that they are effective at delivering nicotine in order to get people to switch, but not so effective that they drive uptake of the product, right? So there's this balancing effect of what's called abuse liability. How likely is it that something is going to help smokers switch, but not be too effective or too addictive that it could get non-users to become addicted? Um, that's called abuse liability or addiction potential. Then you have low youth appeal. How are these products marketed? Again, that's why FDA so far, by and large, has only approved tobacco flavors because they're still really hesitant to approve flavors. And as we'll see in a moment, they just published a new guidance document on flavors. So companies that have those strong marketing controls and manufacturing quality systems are also key features of successful PMTAs. Again, I mentioned this kind of new effort to build in age gating into the hardware itself. Um, and so FDA has indicated in their memos that when it comes to non-tobacco flavors, that products with device access restrictions would have a greater chance of getting authorized than if they didn't have that technology, right? And so again, what we're seeing now is different types of devices coming or technologies being promoted whereby they can either use a biometric tool, a fingerprint scanner, or a Bluetooth connection to your phone, where you can do an ID check or a face check, in order to unlock a device to allow it to be used. And so again, it remains to be seen how effective this type of technology will be. There are concerns about privacy, and whether or not this opens the door to more privacy issues and data collection, particularly from companies that are based in China, and concerns about people suddenly giving away their information to tobacco companies. I mentioned that new guidance. So this is also breaking news. This just came out about a week or so ago. FDA finally published an updated guidance on what they see as the requirements for flavored products. And here in this new guidance, they're doubling down on again the comparative efficacy requirement. Again, the requirement that these products flavors have to be compared to a tobacco flavor version. And there are reasons why that may not make too much sense. I'm happy to discuss later. Um, but basically, what this guidance said, just to boil it down, FDA is saying, okay, we might approve flavors in this industry, in this category, but there are certain flavors that, based on the data we're seeing, are potentially less attractive to youth. Menthol, mint, tobacco, obviously, which is the baseline, but maybe things like coffee, tea, or spice. Those types of flavors um, might have less youth appeal, and so may not need to show as much additional benefit over and above the tobacco flavor. But the more risky flavors in FDA's mind, fruit, candy, dessert, other sweet flavors, are going to have to show an extraordinary amount of benefit to get authorized above a tobacco flavor. Because again, the presumption is that those products are being used by kids and are risky. This is probably true. I'm not going to say it's not true. However, the reality is the marketplace is 95% candy, dessert, fruit flavors, right? Again, for adults, people for adult only locations. And so it's hard to find mint or spice or tea or coffee flavored e-liquid. So again, just based on survey data alone, it seems unclear, how FDA is concluding that these flavors are more attractive if they're just based on the fact that, if you ask young people who vape what they vape, they're most likely going to say a dessert or fruit flavor because that's what's on the market, right? That's what is available, right, to buy. The other ones are less hard to buy. The good news is youth vaping has continued to fall dramatically. So this is a bit of a conundrum for FDA because the narrative is that flavors are driving youth use. However, the reality on the ground is that ever since the 2019 peak, when we had the epidemic, what's called the vaping epidemic, with Juul being the main product being used by high schoolers. At that point in time, almost 28%, 27.5% of high school students in 2019 had said in a survey that they had tried vaping an e-cigarette at least once in the last 30 days. That number has continued to fall dramatically. It was in late 2020 that the federal government changed the age to purchase tobacco from 18 to 21, right? So that was a huge, huge change in the industry. Suddenly, companies that retailers around the country could not sell vaping products to 18-year-olds, which was a source of these products getting into high schoolers. And so in late 2020, December 2020, that law was changed. It raised the age to 21. And since then, the youth vaping rate has continued to fall. And now we're down to 20 in 2025. This was just released about a month or two ago, down to 7.1%. This is a slide that Altria published, and which shows, again, just shows clearly how vaping or tobacco use has declined overall over the last 15 years. And again, you see the peak of vaping in 2019, and that it's since completely fallen off. There was a gap here in 2020 with COVID, and it's continued to decline rapidly, along with smoking, right? The main thing that we're trying to stop here, cigarette smoking, has fallen dramatically. No one could have imagined back in 2011, when almost 16% of high schoolers were smoking, that today we would have less than 2% of youth smoking cigarettes. That's a huge, huge public health victory, no matter no matter how you cut it. So I mentioned, there's sort of some people questioning whether it makes sense for FDA to focus on this tobacco flavor comparison, and the argument being that the real comparator is combustible cigarettes, because vaping products are not inherently tobacco flavored. It kind of defies logic, but they don't actually contain tobacco, and so many people assume that tobacco flavors are the baseline. That's not the case. That's the case for traditional products like cigarettes and a menthol cigarette, which is based off of a traditional cigarette. But when it comes to vaping products, that actually doesn't is not how it works. These are just formulated e-liquids. And so again, the more appropriate public health comparison would be to a combustible cigarette, not to a tobacco flavored e-cigarette, if that makes sense. Briefly, I'm going to talk about nicotine pouches, which are a growing category of products now in the marketplace. FDA has been a lot more comfortable approving these types of products than vaping products. The Zyn is the #1 pouch brand on the market. They received authorization from FDA in 2025. And similar to the vaping market, you have a lot of products on the market that are subject to the exact same. So when it comes to pouches, everything I've talked about today, the PMTA, the compliance policies, the requirements, all of those same requirements apply to pouches. There's no difference, except that when it comes to pouches, FDA is not requiring that tobacco flavored comparison. But this is a growing category. We've seen now more and more companies on the market submitting applications. And last September 2025, FDA announced a pilot program to streamline the review of pouch PMTAs, because they want to clear the backlog, and they're getting a lot of pushback from the industry, saying FDA was sitting on these applications for years and years and years and not approving them. Meanwhile, the black market was taking off. And so FDA announced last year that they were going to complete their reviews of certain pending applications from some of the larger companies to get more approved products on the market. And then the first decision to come out of that pouch pilot program was the On Plus, which is an Altria brand product that was authorized in several flavors again. And that company was able to show that they had significantly reduced toxicant levels compared to cigarettes, and that they also did their own longitudinal studies demonstrating significant success in getting both smokeless tobacco users, that's oral tobacco users, to quit, as well as smokers to significantly reduce their cigarette consumption. So we'll see if FDA continues to approve more pouch products. Very quickly, I'll touch on enforcement. Again, when it comes to enforcement, this is an area where FDA does have authority um, to issue warning letters and import bans, civil money penalties. They can seize products that are unauthorized for sale. They can come after retailers and issue no tobacco sale orders. They can issue permanent injunctions for companies that continue to violate the law. We have seen increased enforcement over the last several years. Here's some headlines that have popped up in the newspapers you might have seen or online. Um, so we are finally seeing significant enforcement of unauthorized products that don't have PMTAs, and that are otherwise violating the law. And so I expect to see more enforcement over the coming years. I'm almost out of time, but I want to briefly touch on state regulation because this was intended to cover both federal and state law. Um, the Tobacco Control Act contains a preemption provision that limits what the states are allowed to do, right? So when it comes to product standards, manufacturing, pre-market authorization, those are all things that are squarely within the FDA's authority, the federal government's authority. When it comes to things that are related to the sales and use of the product, that is within the state's authority. And so you end up having a very complicated checkerboard of laws and regulations around the country, whereby different states have different requirements for licensing, for sales. You'll see flavor bans, you'll see other types of prohibitions that um, make it very difficult to navigate how to distribute these products or sell these products at the state level. At a high level, there are a number of states that have flavor bans. New Jersey, New York, California, which is not on here, is the main. Oh, here it is. California was one of the first states to pass a flavor ban a few years ago. That they now also have something called an unflavored tobacco product list. So if you go into a vape shop or a smoke shop in California, you should not be able to find non-tobacco flavors. If you do, it's because they're being sold illegally, and it's part of this ongoing black market issue. But California was one of the first states to include a flavor ban, among others, that probably about a dozen or so today. And then we also have several large local city bans: New York, Washington, D.C., Chicago. So again, it gets very complicated if you're trying to navigate how to sell these products and avoid, places where it's otherwise illegal. Then you have a number of states that have passed, and a growing number, because every year they're adding more, that are passing what are called certification, PMTA directories or certification laws. What does that mean? The states are recognizing that companies that may have pending applications may be subject to FDA enforcement discretion under that historical compliance policy I mentioned early on. And so we're seeing states pass laws that say, okay, if you can prove to us that your product was on the market prior to the deeming date in 2016, that it was subject to a pending application in 2020 or sometimes 2022 for synthetic nicotine, and that the application is still pending, it has not been denied by FDA, or if it has been denied, that you went to court and got the court to stay the denial. If you can show us you've met each of those criteria, then we will list the product on a directory that is the complete directory of what can be sold in the state. And that makes those products, quote unquote, legal in this state. And so you have here's a sampling of states that now have these types of laws in some way, shape, or form. California, I mentioned, they have what's called the UTL, the unflavored tobacco list. So on top of the flavor ban in California, technically the only tobacco flavored products that can be sold in California need to qualify for the unflavored tobacco product list. which just went live at the beginning of this year, 2026. And so you can Google that and see, what tobacco flavored products are actually included on this list and are therefore legal to sell in California. Again, you have, a number of other states, dozens or so states here that have these laws, and a bunch more that are proposed. So looks like that's my last slide. It's 2 o'clock. I know I'm out of time, but I'm more than happy to stick around and answer any questions.
Alrighty, that looks like that concludes today's presentation. Thank you so much, Azim, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.
Thank you.